Imagine finding out that a house you've been paying for, managing, and pouring years of your life into was sold behind your back. Not by a stranger, not by a shady landlord, by your own brother. And when you go looking for your share of the proceeds from a $175,000 gain, there's nothing. No check, no call, no explanation, just silence. That is exactly the situation one person in Virginia found themselves in. And the legal mess that followed is something every single person who has ever gone in on a property with a family member needs to hear about. Because what happened here isn't just a family drama. It's a cautionary tale about informal agreements, VA loans, property titles, and what the law does and does not protect when your name isn't on a single piece of paper. Let's set the scene. It's 2016 in Virginia. Two brothers have an arrangement. One of them has earned VA loan eligibility through his military service, and they decide to use that benefit to purchase a home together. The house costs $300,000. The plan, as understood between them, is that this is a shared investment. They're in it together, building something, the kind of thing families do. Here's the critical detail that changes everything. When the loan closes and the title is recorded, only one name appears. The brother with the VA loan eligibility. The other brother, the one who believed he was a co-investor, is not on the mortgage. He is not on the deed. From a purely legal standpoint, on paper, he does not exist in this transaction whatsoever. Now, in the real world, this kind of arrangement happens more often than most people realize. VA loans have specific rules that limit who can be a co-borrower. Generally speaking, the VA prefers that all borrowers on the loan be either veterans themselves or, in some cases, a spouse. Adding a civilian sibling as a co-borrower on a VA-backed loan is not straightforward, and in many cases, lenders will not allow it at all. So the workaround that many families use, intentionally or not, is exactly what happened here. One person holds the loan and the title, and the other contributes financially based on a handshake deal or a verbal understanding. That arrangement works fine until it doesn't. For years, things appear to be moving along. The brother who isn't on the loan is contributing to the mortgage payments. He's involved, he believes he has skin in the game, and for a while, maybe that's enough. But then, 2022 arrives, and the situation shifts dramatically. The brother on the loan loses his job. He can no longer make the mortgage payments. So the other brother, our person in this story, steps up and takes over the entire mortgage. Not half, all of it. Every single payment. Think about that for a moment. He is now fully funding a mortgage on a property that legally he doesn't own. But he does it because that's what the agreement was. That's what family does. At least that's what he believed. Then in 2023, he goes even further. He becomes the de facto property manager, finding tenants, handling the rental income, dealing with maintenance, doing everything a landlord does. The property is generating income. It is, by every practical measure, being run entirely by someone whose name appears nowhere in the public record. And then comes 2024, a disagreement. The kind that fractures families. Communication breaks down completely. Weeks pass, maybe months, and then without a phone call, without a text, without any warning whatsoever, the brother who holds the title sells the house. The sale closes in early April 2024 at $475,000. That's a gain of $175,000 over the original purchase price. A significant amount of money. The other brother finds out after the fact. The proceeds are gone, and he is left holding nothing but years of payments, years of labor, and a profound sense of betrayal. So what are the actual legal options here? This is where it gets important, because the law is not completely without tools to address situations like this. It just requires knowing which tools to reach for. The first concept that becomes relevant is something called a resulting trust, or a constructive trust. These are equitable legal doctrines that courts can apply when someone has contributed financially to a property, but wasn't given the legal ownership they were supposed to receive. Essentially, the argument is this. Even though the title only shows one name, the circumstances of the arrangement, the financial contributions, the verbal agreement, the conduct of both parties over time, suggest that the legal owner was effectively holding the property, at least in part, on behalf of the other person. Virginia courts do recognize constructive trust claims, and they can be powerful tools in situations exactly like this one. The second legal avenue is unjust enrichment. This is the argument that one party has benefited financially and substantially at the expense of another, and that allowing them to keep that benefit without any compensation would be fundamentally unfair. When you look at the timeline here, years of mortgage contributions, full assumption of the mortgage payments in 2022, active property management in 2023, the case for unjust enrichment is not a weak one. There's also the possibility of a breach of oral contract claim. Virginia does allow enforcement of oral contracts under certain circumstances, though these cases are notoriously difficult to prove because the evidence is almost always limited to what each person remembers, and memories tend to be very convenient. Documentation, if any exists, texts, emails, bank records, anything that shows the nature of the agreement and the flow of money becomes absolutely critical. Now here's where this story takes a turn that suggests the person in this situation is not without hope. By late April 2025, roughly a year after the sale, they had retained a civil litigation attorney who specializes in business and real estate law. A demand letter was sent in June 2025. That is meaningful. It tells us that a legal professional reviewed the facts and believed there was enough of a case to put formal legal pressure on the other party. Demand letters don't get sent when there's nothing to stand on. What happens next in cases like this can go several different directions. The brother who sold the house might respond to the demand letter and negotiate a settlement. Or he might not respond at all, which would likely lead to a lawsuit being filed. In court, the burden of proof falls on the person making the claim. They would need to demonstrate, through evidence and testimony, that the arrangement was real, that the contributions were real, and that they are owed a share of the proceeds. Bank records showing years of payments. Any written communication acknowledging the arrangement. Witnesses who knew about the agreement. Receipts from the rental management period. Every piece of evidence matters. There's also a potential complication worth acknowledging. Because the original loan was a VA loan, there may be questions about whether the informal arrangement itself created any issues with the lender or with VA guidelines. This is something a competent real estate attorney would need to examine carefully. It doesn't necessarily invalidate the claim for equitable relief, but it's a layer of complexity that shouldn't be ignored. So what can you take away from this? Whether you're the person in this story, or someone who has a similar arrangement with a family member, or someone considering one, here are the things you absolutely need to understand. First, an oral agreement about shared property ownership is worth very little if it's never documented. If you are going to contribute financially to a property, get an agreement in writing, a promissory note, a cohabitation agreement, a partnership agreement, something signed, dated, and witnessed. The cost of drawing up a simple legal document is a fraction of what you'll spend trying to prove an oral agreement ever existed. Second, if your name is not on the title, you do not own the property. I don't care what was said at the kitchen table. I don't care what the understanding was. From the moment the deed is recorded with only one name, that person has the legal authority to sell, refinance, or do whatever they want with the property, and the law will back them up until a court says otherwise. Third, keep records of everything. If you are contributing to a mortgage, pay by check or bank transfer, not cash. If you are managing a rental property, keep every receipt, every lease agreement, every maintenance record. If you and the other party ever acknowledge the arrangement in writing, even in a casual text message, save it, screenshot it, back it up. That evidence could be the difference between a successful legal claim and walking away with nothing. Fourth, if you find yourself in a situation where you believe you've been wronged in a property dispute, time matters. There are statutes of limitations on many of these claims. Waiting too long can permanently close doors that might otherwise be open. If something like this has happened to you, if you've been contributing to a property you don't legally own, or if a shared arrangement has fallen apart without a fair resolution, the most important thing you can do right now is speak with a real estate or civil litigation attorney in your state. Many offer free initial consultations. Do not rely on internet research alone. Get professional legal guidance specific to your circumstances. And if you found this video helpful, consider subscribing. We cover real legal situations that affect real people. The kind of stories that don't make the headlines but can completely upend someone's financial life. Knowing your rights before something goes wrong is always better than finding out after the fact. We'll see you in the next one.